Okay, so what we're going to be talking about for this class period and then next class period and maybe the class period after that, or at least for a couple, is finish up this whole idea of employee protection laws. And really when you think about it, I suppose all laws to some extent are for the protection of the employees, but some are geared more very clearly designed to protect the employees. And we've talked about OSHA in the past, we've talked about ERISA in the past, we talked about workers' compensation laws in the past. Tonight we're going to go just a little bit different angle and talk about family medical leave. We're some Leave Act to protect employees if they need to be off from work. It's the job protection, if you will. So how do you protect their job? And then we'll maybe either next period or period after that we'll get into some COBRA coverage and how you protect insurance. And basically what we're talking about as we conclude this unit on employee protection is laws that protect the employees. So as we look into that and as we get ready to go there, let me ask you this. Let's talk about the Family Medical Leave Act. And what is the Family Medical Leave Act? I mean, what is that? What is that law? In a nutshell, it's in your text. Read a little bit about it. Anybody? Jackie?
It allows you to take 12 weeks off of work if you need to care for your own major medical issue or that of a spouse, or if you've adopted a child or had a child or have a child placed in your care under foster care.
Okay, pretty much. As Jackie says, basically, and that was really the purpose of the Family Medical Leave. Now, we'll talk about how it's been amended over the last couple of years. But the purpose of the Family Medical Leave was to give family members who needed time off to care for a spouse or a child, or for the birth of a child or the adoption of a child, okay, or for a relative family member. And when I say relative, we'll define that, or a family member, we'll define that. But basically, it's a law that's designed to provide protection for those employees who need to take time off and allow them to make sure that they have a job to come back to when they're done taking care of their family member. All right? Now, a couple of things, and we're going to get pretty specific on this, and we'll break it down as we go along. In addition to that, by the way, how many weeks does it generally allow? Anybody? 12. All right? And 12. Basically 12 weeks. However, it's been amended over the last couple of years, particularly in 2009, and there were some amendments that went into effect for military. All right? If you are taking off to leave or to care for somebody who has been injured as a result of being deployed, all right, you actually get 26 weeks. And we'll break that down and just kind of give you the summary of it right now. But that's the gist of the law, if you will. Now, it provides, as far as the coverage, who's responsible, who has to make sure that they apply or comply with that law. It is all employers, okay, it is all employers who employ 50 or more employees within a 75-mile radius. Now, that's the simple nutshell answer, if you will. The Family Medical Leave Act applies to employers who employ 50 or more employees within a 75-mile radius. Now, to determine this 50 magical threshold number that they picked, basically the government wants to see, has this employer employed 50 or more people for 20 or more weeks during this calendar year or the preceding calendar year, all right? So you may have an employer who on one day employs 51 persons, all right? And on another day employs 48. And if they consistently employ 48, the fact that they went one day and employed 51 doesn't mean they're subject to the Family Medical Leave Act. On the other hand, if you have an employer who consistently employs 55 people and for the last week of the year decides to lay off 5 so they won't have to comply with Family Medical Leave Act, government says no, you still comply. So as long as you're basically providing employees, or you're paying employees, you have employees for 20 or more calendar work weeks in the current year or the preceding year, you're going to be covered by the Family Medical Leave Act. Okay? You're going to be covered by that. Basically, the idea is, hey, we're not going to be such a burden on smaller companies. They can't handle it. All right? Now, how do you get into that? That employee relationship is based on 50 or more employees within a 75-mile radius. All right? Within a 75-mile radius. So if I have, in looking to see whether or not I'm covered by the Family Medical Leave, or I have to comply with the provisions of the Family Medical Leave Act, I look and see where the employees are in relationship to other facilities that I may have. If I'm Kraft and I have 100 plus employees right here in Springfield, Missouri, I've got to comply with the Family Medical Leave Act. Okay? There's no doubt about it. If, on the other hand, I have 20 employees here in Springfield and 40 in St. Louis, and that's the extent, I have 2 facilities, do I have to comply with the Family Medical Leave Act? 20 here, 40 in St. Louis. Why not? Because they're not within a 75-mile radius, all right? Similar question, but let's say I have a company in Illinois and I have a company in Missouri. I have 25 in the St. Louis side of Missouri, and I have 60 or 40, let's say 40, on the Illinois side.
Depends on where it's at in Illinois.
Yeah, but if it's within the 75-mile radius, it doesn't matter that it's in 2 different states, okay? So as long as you have 50 or more employees within that 75-mile radius, then you are covered, all right? And you have to comply with the Family Medical Leave Act. Now, in addition to that, you can have what you call integrated employers. And you can have what you call joint employers. And these sometimes overlap. I'll just give you a brief definition of them so you'll understand it. An integrated employer is 2 or more employers. Okay, integrated employers are 2 or more employers that share common management, operations, centralized control of labor relations, and ownership or financial control. Basically, they share things together. The common management, the operations, centralized control of labor relations, and ownership of financial control. Okay? That's an integrated employer. Joint employers is where 2 or more companies control the same employer's working conditions. Okay? 2 or more companies control the same employee's working conditions. Give me an example of what you might think of a joint employer. You may think of one right off the top of their head. The area that you see it most is in temporary agencies, employment agencies, all right? A lot of companies use temporary employment agencies to get their labor, all right? So if a company is using a temporary employment agency, who's going to be the joint employers? Melissa?
The temporary agency and the company.
Yeah, it's going to be the temporary agency and the company, okay? It'll be the temporary agency and the company. And in those situations, if combined together, you get that 50 number in that 75-mile radius threshold, they may be employers, all right? And the Family Medical Leave Act may apply, okay? If you can combine them together to get that. Now, along with that, is you having integrated employers. There are some companies out there that for all practical purposes are one company, but they divide themselves up into smaller companies. Why?
Partially, there's some companies do it, like Microsoft did it, so they didn't have a monopoly share of the industry.
Okay, so they don't have a monopoly share. Why else might they do it, Tom?
No idea.
About what we're talking about tonight.
Yeah, the Family Medical Leave
Yeah, they may not want to comply with the Family Medical Leave Act. I won't give you the name because we're on tape and because I think we have a confidentiality provision. But during my private practice, we sued a particular employer who had an operation. That's what we'll call it. An operation in, say, and I'll give you a couple of cities: Stratford, Marshfield. You get the idea. Somewhere around there. All right. They may have also had an operation in Springfield. They had an operation in Branson. Okay, and they may have different operations. Now, we sued them. They fired an employee that we thought was on family medical leave, should have been family medical leave, and their defense was, we don't have 50 or more employees. And you're right, because, and they were right, from the standpoint that their facility in Stratford, Marshfield, Conway, wherever we want to say it is, was one corporation. Their facility in Springfield was another corporation. Their facility in Branson, or wherever it was another corporation. Okay? Now, the reason we went ahead, I mean, we know this before we go in and file suit. We just don't say, oh, you know, we do our homework. And the reason we went ahead and filed suit was because when they advertise, they all use the same ad. They have the same website, okay? When we look to see how they were paid, they're all paid out of one facility. They're all, human resources is in one facility. So if the person that's in Stratford, Conway, wherever we want to say, has a question about human resources, they have to go to a facility in Springfield, okay? If somebody in Springfield, one of the facilities or operations in Springfield has it, they have to go to that facility in Springfield. If there's one in Branson, they have to go to that facility in Springfield. And so from that, we said, you know what, you may have different little shells set up, but they're all integrated employers because you have common management, common operations. Your human resources are all out of the same department. I was reading recently in the Springfield Business Journal, their operation was in there, and they counted all of their facilities. You know, they list how many employees. If you've ever read the Springfield Business Journal, they have a section where they say how many employees they have. It was interesting, and I wanted to call up their attorney and say, really, I thought they were going to fix this, but they've listed the total number of employees, which would be the total number of employees if you count their Conway, Stratford, wherever it is, Springfield, and Branson, wherever it is. So it's interesting, when it's convenient, they want to be one employer. When it's not so convenient, they want to be, you know, multiple employers separate. So just because you set up these separate corporations and say, well, we're not going to hire more than 50, and this is Corporation ABC, and this is Corporation DEF, and this is, you know, XYZ or whatever, you can still comply or have to comply with the Family Medical Leave Act. The other thing with regard to the employer situation is successors in interest can also be responsible for the Family Medical Leave Act, all right? So, and what do I mean by successor in interest? Anybody? What's a successor in interest? Successor in interest is just somebody who buys out a company or takes over a company, okay? And if they continue to employ the same employees, okay, at the same location, same operations, then they are a successor in interest. And they may still have to comply with the Family Medical Leave Act. Okay? As if their predecessor had also, if their predecessor had complied with it. Okay? So, basically you get the idea. For the most part, 50 employees, 75-mile radius, but you can tack employees together through this joint employer, integrated employer, whatever. All right. Now, what's an eligible employee? Not every employee is eligible for the Family Medical Leave Act. All right. If you show up one day a week and work 1 hour a week for all year long, you're not going to be eligible. Basically, here's what the eligibility requirements for Family Medical Leave Act benefits are. Okay? Number one, you must be employed at a work site where you have 50 or more people in a 75-mile radius. So if, for instance, let's break that down. If you're an employee and a company has 20 employees, say here in Springfield, okay, another 40 in Marshfield, at that point, do we have the family medical leave? Yes. All right. Now let's say we go from Marshfield to another facility in St. Louis where there are just 5 employees. Now we're outside that 75-mile radius. Those 5 employees in St. Louis may not get the rights to the Family Medical Leave Act. Okay? So you have to be at a facility where 50 or more workers are employed within a 75-mile radius. All right? You also have to have worked for the company for at least 12 months. So you don't get to show up to work 1 week, say, oh, by the way, I forgot to tell you I'm having a baby and I want to come back. Okay? So you have to work for at least 12 months. Now, let me say this about that 12 months. It doesn't necessarily have to be consecutive. So if I worked for a company and then I leave and then I come back, I may be able to tack that on. If I've been away from that company for more than 7 years, no, I don't get to tack it back on. And you get into some tricky stuff with National Guard, and we're not going to get into all that. Amanda?
I just have a question.
Yeah.
Like a specific scenario, if someone is pregnant and they haven't been at their place of employment for 12 months, but before they give birth, they will have.
Okay.
Can the employer fire them once they find out they're pregnant?
Probably not.
Okay.
But we haven't talked about that yet. The reason that they haven't, and we probably won't talk about that for a few more weeks. There is an act that we'll talk about in this class later on called the Pregnancy Discrimination Act, okay, PDA, and it's more than just your personal digital assistant or whatever they call those things, all right? So if they weren't there for a year, and that's a great question, if they weren't there for a year, they would be able to fire them if it were just the Family Medical Leave Act. But you get into some issues with the Pregnancy Discrimination Act that may prevent them from firing them. Okay, and we'll talk about that. That's a great question. But and that's why you can't ever, we talk about these laws from week to week, but you really can't look at these laws in isolation because you have to consider all of them. And the good HR person will say, okay, I've got a person who's pregnant. Does it apply? Is there an ADA or Americans Disabilities Act? Is there, do I have work comp? What do I have? Do I have family medical leave? I don't know how you get a pregnancy out of a work comp situation, but who knows? Who knows what can happen? But you have to look at all those laws. But under a pure Family Medical Leave Act, would not have to. Okay. Now, in addition to the 12 months before the leave, they have to work at least 1,250 hours. I haven't calculated that lately, and somebody might be able to do it. The last time I looked at it, it was somewhere between 24, 28. That would average around 28 hours a week or so, average. Okay, so you don't have to be a full-time employee to be entitled to the Family Medical Leave Act, but you have to work enough to have 1,250 hours in the last 12 months before that leave begins. Okay? All right. So, what are the reasons? Well, we talked, and Jackie gave us some of the reasons, and we'll talk about some of those reasons. Birth is one of those reasons, okay? The birth and care of a newborn child is one of the reasons you're entitled to take family medical leave. The placement of a child for adoption or foster care is another reason. Okay, adoption. Okay. To care for a parent spouse or child who has a serious health condition. Now, under the family medical leave, it is also to care for active duty leave, or because an employee's circumstances qualify under active duty leave, if you will. That's how we should say it. Because a spouse, parent, or child is being deployed. Or for military caregiver leave for a service person who has been injured while in active duty in the armed forces. Okay. Now, let's talk a little bit about what family members are, and because the Family Medical Leave Act is a little bit different than some. We have talked before in here, and we'll talk again, that gender preferences may or may not be protected. We've talked in here in terms of ERISA, that same-sex marriages, if you will, may not be protected. That is not the case under the Family Medical Leave Act. Under the Family Medical Leave Act, a parent is, well, let's start with a child. A child, basically somebody who's 18 or under, unless they have a disability, all right? So a child who has a disability may qualify under the, a person with a disability may be a child even though they are older than 18. All right. For instance, I have one of our kids is pretty severe epilepsy. All right. Wouldn't know it for the most part, but spend a lot of time, pretty much controlled now with medication, but spend a lot of time over the last few years in St. Louis working with our doctors and epilepsy doctors there and trying to evaluate what could be done, what couldn't be done. He turns 18 in 6 months, 7 months. But our doctor's already told us he will not be able to live by himself, okay? So until we can find him a spouse to take care of him, and we're looking, believe me, we are looking, all right? He's going to be around. That's great. That's fine. And I say that partially in jest, but truthfully, he would probably qualify because of his condition and the limitations on that as a result of that condition. He would, if I needed time off from work to take care of him and I needed more than just a week, my employer would probably have to say, hey, we got to give it to Greg because he would qualify for family medical leave, even though my child is above the age, or soon to be above the age of 18. All right. In addition to that, a child is defined as a child. I love that. They define child as a child of a parent or a person who has day-to-day responsibilities for that child. Okay? Now, with that, and let's just go ahead and define parent here, a parent is a biological, adoptive, step, foster father, mother, or any other individuals who have day-to-day responsibilities to care for the children, all right? So when you think and you hear this law for the first time, you may just think, well, biological father, biological mother leave to take care of their child. Not the case. Could be a step-parent, all right? So it doesn't have to be a biological parent. But it could also be, if you have a situation where you have two people of the same sex who are in a relationship and one of them is taking care of the child of the other person in that relationship from a prior marriage, the person taking care of the child is entitled to family medical leave. Okay? Does that make sense? I don't know if I spelled that scenario out. But it doesn't have to be your typical situation that we might normally think of. The family medical leave gives a little more protection there than other laws. So it also depends upon the protection of a state. Okay, spouse. We talk about child, we talk about parent. Spouse is based upon, it's what you would think it is, but it's defined by state law. So if you're in a state where the state defines a same-sex partner as a spouse, family medical leave applies. If you're in a state where same-sex does not include or a spouse of the same sex is not defined as a spouse, or a person of the same sex not defined as a spouse, then it's not included. Okay? Does that make sense? So you really have, depending upon the law you're in, different protections under the Family Medical Leave Act. Okay? Now, how many weeks for the most part? 12. Okay? The exception to that is 26 when you have somebody who has been injured while being deployed. Okay? And so they get up to 26 weeks of leave. All right. Let's define then, so that this idea of the Family Medical Leave Act is to give a person time off from work in order for them to care, okay, for a serious health condition of a family member, okay, parent, child, spouse, okay, one of those. What is a serious health condition? For the most part, a serious health condition is not the flu, all right? It's not an earache, not going to the dentist, all right? Generally, it is an illness, injury, or condition that involves inpatient care or, and you might circle the word or, so it involves inpatient care or continuing treatment by a provider. Okay? So it involves treatment, inpatient care, or continuing treatment by a healthcare provider. Now, treatment can include that initial examination to diagnose what's wrong. However, it doesn't generally include eye examinations, routine physicals, things of that nature. But if I have a serious, my father-in-law went to, had a serious chest pain 3 or 4 weeks ago, goes into the hospital, okay? Thankfully, was not a heart attack, but that diagnosis of going into the hospital, and he may have been admitted, was admitted, but that diagnosis, okay, in and of itself would have constituted some treatment. And then if he has to come back for additional treatment and examinations 3 or more times, then he would have a serious health condition. If he just had the examination and is released, it is not a serious health condition. Okay? So serious health condition involves inpatient care or continuing treatment. And continuing treatment usually requires 3 or more times. And when I say that, the incapacity has to be, there has to be an incapacity that lasts 3 or more days, 3 or more consecutive days. Okay? So if he goes to the doctor, they say, hey, you're just having heartburn, which is not the condition. But if they said, you're just having heartburn, you're released, that will not qualify for family medical care. Okay? But incapacities that last 3 or more days, calendar days, and consecutive calendar days, generally will constitute treatment and will constitute a serious health condition. Okay? Yeah, Melissa.
Is there a limitation as far as like, say someone, you have a spouse that has had cancer, you're off for your 12 weeks, go into remission, cancer comes back 3 months later, then you also get your 12 months again, 12 weeks again?
Yeah, we'll talk about that. That's a great question. How do you define that 12-week period? And we'll talk about the different ways to define that. But no, that's a great question. And cancer is one of those things, if there's a regimen of treatment, okay, and you have to go back on a regular basis, then you may qualify for it, okay? I don't want to get into all of the details on incapacities and what they are, because, I mean, it gets pretty complicated, and so it's like a maze, if you will. And I don't want to get that deep into it. I want to give you the basis of the Family Medical Leave Act. But basically, you have to have a serious health condition, okay? And if you don't have a serious health condition, then you're not going to qualify for Family Medical Leave Act, okay? Now, in order to get that, or what leave do you get? Well, you get 12 weeks, all right? And so let's go to what Melissa was talking about as how do you determine what that 12 weeks, how that 12 weeks is consists of. There are basically, it is up to the employer to decide, okay? And there are a number of ways that that 12-week period can be decided. But here are the four. Let me give you the four main ones, okay? Number one, easy, calendar year. Okay? So you can designate that 12-week period will be a calendar year. If you're an employer and you want to designate it as a calendar year, you can do it. Okay? Second way you can do it is any 12-month period, such as a fiscal year or an anniversary date of an employee. So that can be the 12-month period. The third way is to measure the 12 months from the date the employee first takes the leave. So, the employee says, I need to be gone for a pregnancy. That begins day one, and then you have 12 months after that. The fourth is the rolling, what we call the rolling, ROLLING, 12-month period backward. Okay. It's the rolling 12-month period backward from the date the employee takes leave. So basically what you do in that rolling backward is the employee comes in and says, I need leave for pregnancy. All right. You stop right then, you look at that day, and you go backwards to see how many days have been used. All right. To see how much time the employee has for leave. Okay. And we'll walk through those. The Family Medical Leave Act gives the employer the right to designate which one of those four mechanisms they will use to measure. Now, let's go back through those. Why would an employer, and by the way, if the employer doesn't designate, this is why when you're out there and you're practicing in human resources and you're looking at handbooks, you want to make sure that your handbook designates it. Almost everybody's does now, but you want to make sure that if you're writing one for a particular company that you designate it, because if you fail to designate it as an employer, the employee gets whatever one's most beneficial for them. Now, as an employer, why don't you want to use the first one, which is, or the first two, really, for that matter, the calendar year, or the fixed anniversary date? Why might I not want to use, let's just stick with the calendar year. Really, it'll be the same for both of them. But why might I not want to use the calendar year? Jackie?
Well, it's like if someone has a child, or like, it'd be easier to plan probably like an adoption. If they plan their adoption such that they would use up like 11 weeks at the end of the year, and then you rolled over to a new calendar year, and then they could take 12, consecutive to that, they have a ton of time off and can't do anything about it.
Right, yeah. Jackie says, and you're absolutely right, it works better just from a biological standpoint if we're dealing with adoption, okay? Because not many people, will have pregnancy and then immediately, okay, that'll be a unique situation. But certainly, an adoption would be a good example, all right? Because then the person who's adopting can plan an adoption so that, and we're coming toward the end of 2012, all right? So that, here we are in October, all right? So if I want to adopt, say tomorrow, I can take off the rest of October, November, December, there's my 12 weeks, all right? Now, if I've done it on a calendar year, if the employer has designated that my 12-month period in which I'm allowed to take 12 weeks off is within a calendar year, guess what? As Jackie says, I can now start adopting in January, and now I can have January, February, March off, and the employer can't do anything about it. Now, that generally doesn't happen, but still, you get into a situation where somebody who has a serious injury, even the best employers cannot hold a position forever. They may want to, but they can't hold it forever. And the same thing happens. If you get somebody who's injured and you say, we'd love to work with you, if you don't have it designated, you'll have to work with them so that not only do they get that October, November, December off, then they get January, February, March off. Same thing with the anniversary date. It could happen the same way, all right? The one that most employers use, and I really think it's probably the most fair one, is the rolling one. So that you look at where you're going to be, all right? And then you go backwards. So if we take our adoption situation or our pregnancy situation, and let's say I want to adopt tomorrow, okay? And I want to take 12 weeks off for that, okay? We'll start right now, and we'll start with today. Now, the employer says, well, you've got some time, but you've only got 8 weeks. And I go, no, I've got 12 weeks because the family medical leave says I have 12 weeks. And you go, no. The employer says, no, you only got 8 weeks. Because remember, 2 months ago, you ran and knocked yourself, fell into a wall, broke your arm, and you took 4 weeks off because you broke your arm. You see what I'm saying? So today, I look back and I've used 4 weeks over the last from today, so I now only have 8 weeks left. All right, so it's a rolling period. Does that make sense? And so it's a fair way, probably, for both employer and employee. Otherwise, as Jackie says, they can almost stack. Employees can almost stack family medical leave. Okay. Any questions with regard to that? Yeah, Jackie.
This kind of goes back to the definition of child.
Okay.
Okay, so for example, my younger brother and I are really far apart in age. If something, God forbid, happened to my parents and he was placed, under my care, I guess it's kind of a two-part question. Would he be defined as a child, because he would be in my day-to-day care, would he be defined as a child for me if, something were to happen to him? Or could I take time off, if I qualified for the very fact that he was placed under my care?
Let's take it one at a time.
Okay.
With regard to the first part, you would be a parent.
Okay.
Because, if for no other reason, because parent is defined as someone who has day-to-day responsibility for his care and financial control. Okay? So from that standpoint, you would be defined as a parent. Now, and that's where you're going to get. Child is also defined as biological, adopted, foster son or daughter, stepchild, legal ward.
Okay.
So if you were appointed as a custodian through the court, that would count as well. Okay? Okay. Good question. All right. Any other questions with regard to that? Okay. So that kind of gives you the breakdown of where it is. Now, hang on. Tell you what, let's stop there for just a few minutes, and we'll pick this up next time.